Senator Grassley.
Okay. I do this as a point of personal privilege, Mr. Chairman, and I appreciate that courtesy of you and the members. This is the first meeting of the Senate Judiciary Committee in this 116th Congress. It's also the first time that we convene while my friend Lindsey Graham holds the gavel and will proceed to be chairman. So I'd like to congratulate the new chairman, thank him for his leadership, and say that I look forward to working with you and other members of this committee as we seek to address some of our nation's most pressing problems. I have every confidence that you'll steer our 200-year-old committee in the right direction.
Well, thank you. I really appreciate that. In my view, nobody looks over 100, so we're actually we're aging well as a committee. The bottom line is, how do you get this job? Your colleagues have to vote for you. Thank you. You have to get reelected and outlive the person to your right. So I've been able to do that, and I look forward to working with Senator Feinstein, who is, I have a lot of affection and fondness for. She, to me, represents a seriousness that the body needs and a demeanor that I think we should all aspire to. To the new colleagues, Senator Hawley, Blackburn, and Ernst, thank you for being part of this committee. To Senator Blackburn and Ernst, thank you for making history, I think, on our side. As to the hopes and dreams for this committee, to get as much done as possible and to fight when we have to over things that matter to the public and show two different views of an issue that's important, but do it as respectfully as possible. Sentencing reform, criminal justice reform was a very big deal. And this committee delivered for the country. Senator Durbin, I want to thank you very, very much for working with Senator Lee and Senator Grassley and Senator Booker. That's a big deal that's going to change lives, I think, in a positive way. So this committee has within it the ability to do big things long overdue. I know Senator Blackburn wants to do something on social media. Senator Klobuchar's got some ideas about how to make sure if you put an ad up on social media, you have to stand by it. We're all worried about the social media platforms being hijacked by terrorists and bad actors throughout the international world. We're worried about privacy. Do you really know what you're signing up for when you get on one of these platforms? I'd like this committee working with Commerce to see if we can find some way to tame the Wild West. Intellectual property, Senator Tillis and Senator Coons have some ideas that I look forward to hearing about. Senator Sass wants to make sure that we act ethically. You got a package of ethic reforms, and I look forward to working with you there. On this side, I know there are a lot of ideas that I'm sure that if we sat down and talked, we could embrace, and I look forward to solving as many problems as we can and having a contest over ideas that really matter to the American people. Senator Hatch, thank you for coming. In terms of my chairmanship, if I can do what you and Senator Grassley were able to do during your time, I will have done the committee a good service. Senator Grassley, thank you very much. Last year was tough, but I think you and Senator Feinstein did the best you could in the environment in which we live. The times in which we live are very difficult times. I don't see them getting better overnight, but I do see them getting better if we all want them to. So about me, I want us to do better, and I'll be as measured as possible. The immigration Lindsey will show up, but the other guy's there too, and I don't like him any more than you do. So the bottom line is we're starting off with something that would be good for the country. We have a vacancy for the Attorney General spot. We have a chance to fill that vacancy. Mr. Barr is, you can't hold a job. When you look at what he's done in his life, it's incredible. So I want to thank the President for nominating somebody who is worthy of the job, who will understand on day one what the job is about, and can right the ship over there. I think we all have concerns. I know Senator Whitehouse is passionate about cybersecurity. and Fort Cyber and all these other ideas that Sheldon has been pushing. It's just a matter of time before we hit hard if somebody doesn't step up to the plate with some solutions. But a little bit about the nominee. He's been Attorney General before, from 91 to 93, by voice vote. Those were the days. Deputy Attorney General from 90 to 91, unanimous consent without a recorded vote. Assistant Attorney General, Office of Legal Counsel, voice vote. That's pretty amazing. I think you're going to have an actual vote this time. Academically gifted, George Washington Law School, Columbia University undergraduate. Outside of DOJ, he was the General Counsel, Legislative Counsel for the CIA. That's how he met Bush 41. He's been a law clerk. He's worked in private practice. I'm not going to bore the committee with all the things he's done. He's been the Senior Vice President, General Counsel of GTE. He's lived a consequential life, General Counsel for Verizon. You've lived a life that I think has been honorable and noteworthy and accomplished, and I want to thank you for being willing to take this task on. We got a lot of problems at the Department of Justice. I think morale is low, and we need to change that. So I look forward to this hearing. You will be challenged. You should be challenged. The memo, there'll be a lot of talk about it, as there should be. But I just want to let you know, Mr. Barr, that we appreciate you stepping up at a time when the country needs somebody of your background and your temperament to be in charge of the rule of law. And with that, I will turn it over to my colleague, Senator Feinstein.
Thanks very much, Mr. Chairman. And I want you to know I really look forward to working with you.
too.
And I think we can work productively together. And Senator Grassley, I want to thank you for the time we worked together. It really was a pleasure, and I had an opportunity to get to know you as the fine person that you are. So thank you very much. I want to say just one word or two or three about women. 25 years ago, there were no women on this committee. I'll never forget watching the Anita Hill hearing on a television in the London airport with a lot of people gathered around. So I went over to take a look, and I saw this all-male Judiciary Committee. And it took all these years, but here we are. And I want to particularly welcome Senator Ernst and Senator Blackburn. I think it's extraordinarily important that this committee be representative of our society at large, and we are growing that way. And so thank you very much for being here. I'd also like to welcome Bill Barr and his family. I know you're proud to be here, and you served as Attorney General before from 91 to 93, and I think we all have great respect for your commitment to public service. When we met, your previous tenure marked a very different, we talked about a very different time for our country. And today we find ourselves in a unique time with a different administration and different challenges. And now, perhaps more than ever before, the country needs someone who will uphold the rule of law, defend the independence of the Justice Department, and truly understand their job is to serve as the people's lawyer, not the president's lawyer. Top of mind for all of us is the ongoing Mueller investigation. Importantly, the Attorney General must be willing to resist political pressure and be committed to protecting this investigation. I'm pleased that in our private meeting, as well as in your written statement submitted to the committee, you stated that it's vitally important, and this is a quote, that the special counsel be allowed to complete his investigation, end quote, and that, quote, the public and Congress be informed of the results of the special counsel's work, end quote. However, there are at least two aspects of Mr. Mueller's investigation. First, Russian interference in the United States election, and whether any U.S. persons were involved in that interference. And second, possible obstruction of justice. It's the second component that you have written on. And just 5 months before you were nominated, I spent the weekend on your 19-page legal memo to Deputy Attorney General Rod Rosenstein criticizing Mueller's investigation, specifically the investigation into potential obstruction of justice. In the memo, you conclude, I think, that Special Counsel Mueller is, quote, grossly irresponsible for pursuing an obstruction case against the president. And pursuing the obstruction inquiry is fatally misconceived. So I hope we can straighten that out in this hearing. But your memo also shows a large sweeping view of presidential authority and a determined effort, I thought, to undermine Bob Mueller, even though you state you have been friends and are in the dark about many of the facts of the investigation. So it does raise questions about your willingness to reach conclusions before knowing the facts and whether you prejudge the Mueller investigation. And I hope you'll make that clear today. It also raises a number of serious questions about your views on executive authority and whether the president is, in fact, above the law. For example, you wrote, "The president," and I quote, "alone is the executive branch. As such, he is the sole repository of all executive powers conferred by the Constitution. Thus, the full measure of law enforcement authority is placed in the president's hands, and no limit is placed on the kinds of cases subject to his control and supervision." This is in your memo on page 10, and I will ask you about it. This analysis included cases involving potential misconduct, where you concluded, and I quote, "The president may exercise his supervisory authority over cases dealing with his own interests, and the president transgresses no legal limitation when he does so." That's on page 12. In fact, you went so far as to conclude that, quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he has a personal stake." You also wrote, "The Constitution itself places no limit on the president's authority to act on matters which concern him or his own conduct," page 10. Later, you conceded that certain supervisory actions, such as the firing of Director Comey, may be unlawful obstruction. However, this too is qualified. You argue that in such a case, obstruction of justice occurs only if first a prosecutor proves that the president or his aides colluded with Russia. Specifically, you conclude, and I quote, "The issue of obstruction only becomes ripe after the alleged collusion by the president or his campaign is established first," end quote. So that's some of the things I hope to ask you about. And in conclusion, let me just say that some of your past statements on the role of Attorney General and presidential power are concerning. For instance, you've said in the past that the Attorney General is the president's lawyer. In November of 2017, you made comments suggesting it would be permissible for the president to direct the Justice Department to open an investigation into his political opponents. And this is notable in light of President Trump's repeated calls for the investigation of Hillary Clinton and others who disagree with him. I believe it's important that the next Attorney General be able to strongly resist pressure, whether from the administration or Congress, to conduct investigations for political purposes. He must have the integrity, the strength, and the fortitude to tell the president no, regardless of the consequences. In short, he must be willing to defend the independence of the Justice Department. So my questions will be, do you have that strength and commitment to be independent of the White House pressures you will undoubtedly face? Will you protect the integrity of the Justice Department above all else? Thank you very much, Mr. Chairman.
Thank you, Senator Feinstein. Well, Senator Hatch, welcome back. We truly miss you. You were a great chairman and an incredible member of this body, and you're very welcome to share your thoughts about Mr. Barr with this committee.
Well, thank you so much, Mr. Chairman, Ranking Member Feinstein as well, and members of the committee. It is my distinct pleasure to be here today to introduce William Barr, the President's nominee to be Attorney General of the United States. I have known and worked with Bill closely over the years, and I'm glad to call him a friend. Bill has had a distinguished career in public service and in the private sector. He started his career at the Central Intelligence Agency. While there, he went to law school part-time at George Washington University. Following graduation, he was selected for a prestigious clerkship with a federal judge on the D.C. Circuit before heading to private practice. Later, he served in the Reagan White House in the Office of Policy Development. Following another stint in private practice, Bill began his distinguished career at the Department of Justice under President George H.W. Bush. Bill served as the Assistant Attorney General for the Office of Legal Counsel, then as Deputy Attorney General, and finally as Attorney General of the United States. As Attorney General, Bill oversaw a number of sensitive criminal investigations, including the investigation into the Pan Am Flight 103 bombing. He prioritized fighting violent crime and became known as the Law and Order Attorney General. Throughout his time at the Justice Department, Bill earned a reputation as a fierce advocate for the rule of law, as a principled and independent decision maker, and as a lawyer's lawyer. He has shown his commitment to the Constitution time and time again while serving our country. That is why he has been confirmed by the Senate unanimously 3 times. After completing his service at the DOJ, Bill returned to the private sector working at law firms and as counsel for some of America's largest companies. I could go on at length describing Bill's distinguished career. There is no question, none whatsoever, that Bill is well qualified to serve as Attorney General. He has held this position before and won high praise during his tenure for his fairness, his tenacity, and his work ethic. So instead of droning on about Bill's resume, I want to tell you about what Bill identifies as the most important achievement of his private service as Attorney General. At least I believe this is what he believes. I believe his answer tells you much about how he will approach the job and who he is. When asked what his most important accomplishment was as Attorney General, Bill does not point to one of his many policy successes. He doesn't talk about his role in setting antitrust merger guidelines. He doesn't say it was his role leading the DOJ's response to the savings and loans crisis. No, for him, it was something more. It was something more tangible. It was Talladega. 3 days after Bill was named acting Attorney General by President Bush, 121 prisoners noted and seized control of the Talladega Federal Correctional Institution in Alabama. This was a very serious matter, and they took 10 hostages. Planning at the DOJ began immediately for how best to resolve the situation and secure the safe release of the hostages. In such a situation, some would have sought political cover, not Bill. He was in charge. He knew the response was his decision to make, his responsibility. He maintained his focus on the safety of the men and women held hostage by the prisoners. The standoff lasted 10 days. Then, on Bill's order, FBI agents stormed the prison. 3 minutes later, it was over. The hostages were safe. The mission was well planned and executed. that federal agents do not even have to fire a single shot. Bill's decision-making and judgment helped save lives. When President Bush nominated Bill to be Attorney General in 1991, I noted why he had been selected. He was not a member of President Bush's political or personal inner circle. He was not a part of the president's brain trust. He was not a politician or former politician who brought political clout to the position from prior elections or prior elected office. Bill Barr was a lawyer's lawyer. Talent, merit, and performance. Those were the reasons President Bush selected him to be the Attorney General at that time. That statement holds true today. Bill Barr, in my opinion, is an outstanding choice for Attorney General. His vast experience, renowned judgment, and reputation as an ardent defender of the rule of law make him a nominee that the American people, the President, and the Senate should all be proud of. So I feel very honored to be here today to speak in his favor, and I hope that his nomination will be approved expeditiously. Thank you, Mr. Chairman.
Thanks, Senator Hatch. I'd like to note at the outset that the rules of the Senate prohibit outbursts, clapping, or demonstrations of any kind. This includes blocking the view of people around you. Please be mindful of these rules. As we conduct this hearing, I will ask the Capitol Police to remove anyone who violates the rules of this committee. Thanks, Senator Hatch. Ms. Barr, would you come forward, please?
Thank you.
Raise your right hand, please. Do you affirm that the testimony you're about to give to this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Floor is yours.
Before I begin, Mr. Chairman, could I introduce my family?
Absolutely.
My wife of 46 years, Christine, a retired librarian. My daughter, Margaret, who we called Meg, she was an assistant United States attorney in the District of Columbia, but now has moved up to Capitol Hill and works for Senator Braun. My middle daughter, Patricia, who's also an attorney, and she has been counsel to the House Agriculture Committee for how long now, Patty? 10? 11 years. And my daughter, Mary, who is a longtime federal prosecutor and is currently the coordinator for opioid enforcement in the Office of the Deputy Attorney General. Mary's husband, Mike, who is also an attorney at the Department of Justice in the National Security Division, and their son, Mary and Mike's son, Liam, who will someday be in the Department of Justice. Patricia's husband, Pelham, who is a founding partner of a consulting firm, and Meg's husband, Tyler, who is also an assistant United States attorney in the Eastern District of Virginia. Did I leave anyone out?
Think about medical school, Liam. Somebody needs to make money in the family.
When Meg was starting at Notre Dame, I told her I wanted a doctor in the family, and I made her take organic chem. Needless to say, she's now a lawyer, so. Good morning, Mr. Chairman, Ranking Member Feinstein, and members of the committee. It's a privilege to come before you today, and I'm honored that President Trump has nominated me for the position of Attorney General. I regret that I come before this committee at a time when much of our government is shut down, and my thoughts are with the dedicated men and women of the Department of Justice and other federal workers, many of whom continue to perform their critical jobs. As you know, if the Senate confirms me, this would be my second time I would have the honor of holding this office. During the 4 years I served under President George H.W. Bush, he nominated me for 3 successive positions, in the department, the Assistant Attorney General for the Office of Legal Counsel, the Deputy Attorney General, and finally the Attorney General. And this committee unanimously approved me for each of those offices. 27 years ago at my confirmation hearing, I explained that the Office of Attorney General is not like any other cabinet post. It is unique and has a critical role to play under our constitutional system. I said then, the Attorney General has a very special obligation, unique obligations. He holds in trust the fair and impartial administration of justice. It is the Attorney General's responsibility to enforce the law even-handedly and with integrity. The Attorney General must ensure that the administration of justice, the enforcement of the law, is above and away from politics. Nothing could be more destructive of our system of government, of the rule of law, or the Department of Justice as an institution than any toleration of political interference with the enforcement of the law. I believe this as strongly today as I did 27 years ago, indeed more strongly. We live in a time when the country is deeply divided. In the current environment, the American people have to know that there are places in the government where the rule of law, not politics, holds sway, and where they will be treated fairly based solely on the facts and the even-handed application of the law. The Department of Justice must be that place. I did not pursue this position, and when my name was first raised, I was reluctant to be considered and indeed proposed a number of alternative candidates. I'm 68 years old, partially retired and nearing the end of a long legal career. My wife and I were looking forward to a peaceful and cherished time with our daughters and grandchildren. And I've had this job before. But ultimately, I agreed to serve because I believe strongly in public service. I revere the law. I love the Department of Justice and the dedicated professionals who serve there. And I believe that I can do a good job leading the department in these times. If confirmed, I will serve with the same independence I did in 1991. At that time, when President Bush chose me, he sought no promises and asked only that his Attorney General act with professionalism and integrity. Likewise, President Trump has sought no assurances, promises, or commitments from me of any kind, either express or implied, and I have not given him any, other than that I would run the department with professionalism and integrity. As Attorney General, my allegiance will be to the rule of law, the Constitution, and the American people. This is how it should be, this is how it must be, and if you confirm me, this is how it will be. Now let me address a few matters I know are on the minds of some of the members of this committee. First, I believe it is vitally important that the special counsel be allowed to complete his investigation. I have known Bob Mueller for 30 years. We worked closely together throughout my previous tenure at the Department of Justice. We've been friends since, and I have the utmost respect for Bob and his distinguished record of public service. And when he was named special counsel, I said his selection was good news, and that knowing him, I had confidence he would handle the matter properly, and I still have that confidence today. Given his public actions to date, I expect that the special counsel is well along in his investigation. At the same time, the President has been steadfast that he was not involved in any collusion with Russian attempts to interfere in the election. I believe it is in the best interest of everyone, the President, Congress, and the American people, that this matter be resolved by allowing the special counsel to complete his work. The country needs a credible resolution to these issues. And if confirmed, I will not permit partisan politics, personal interests, or any other improper consideration to interfere with this or any other investigation. I will follow the special counsel regulations scrupulously and in good faith, and on my watch, Bob will be allowed to finish his work. Second, I also believe it is very important that the public and Congress be informed of the results of the special counsel's work. My goal will be to provide as much transparency as I can consistent with the law. I can assure you that where judgments are to be made, I will make those judgments based solely on the law, and I will not let personal, political, or other improper interests influence my decision. Third, I would like to briefly address the memorandum that I wrote last June. I wrote the memo as a former Attorney General who has often weighed in on legal issues of public importance, and I distributed it broadly so that other lawyers would have the benefit of my views. My memo was narrow, explaining my thinking on a specific obstruction of justice theory under a single statute that I thought, based on media reports, the special counsel might be considering. The memo did not address or in any other way question the special counsel's core investigation into Russian efforts to interfere in the election, nor did it address other potential obstruction of justice theories or argue that some have wrongly suggested that a president can never obstruct justice. I wrote it myself on my own initiative without any assistance and based solely on public information. I would like to comment very briefly on my priorities if confirmed as Attorney General. First, we must continue the progress we've made on violent crime, while at the same time recognizing the changes that have occurred since I last served as Attorney General. The recently passed First Step Act, which I intend to diligently implement if confirmed, recognizes the progress we have made over the past 3 decades in fighting violent crime. As Attorney General, I will ensure that we will continue our efforts to combat violent crime. In the past, I was focused on predatory violence, but today I am also concerned about another kind of violence. We can only survive and thrive as a nation if we are mutually tolerant of each other's differences, whether they be differences based on race, ethnicity, religion, sexual orientation, or political thinking. And yet we see some people violently attacking others simply because of their differences. We must have zero tolerance for such crimes, and I will make this a priority as Attorney General if confirmed. Next, the Department will continue to prioritize enforcing and improving our immigration laws. As a nation, we have the most liberal and expansive immigration laws in the world. Legal immigration has historically been a huge benefit to this country. However, as we open our front door and try to admit people in an orderly way, we cannot allow others to flout our legal system by crashing in through the back doors. In order to ensure that our immigration system works properly, we must secure our nation's borders, and we must ensure that our laws allow us to process, hold, and remove those who unlawfully enter. Finally, in a democracy like ours, the right to vote is paramount. In a period of great political division, one of the foundations of our nation is our enduring commitment to the peaceful transition of power through elections. If confirmed, I will ensure that the full might of our resources are brought to bear against foreign persons who unlawfully interfere in our elections. Fostering confidence in the outcome of elections also means ensuring that the right to vote is fully protected, as well as ensuring the integrity of elections. Let me conclude by making the point that over the long run, the course of justice in this country has more to do with the character of the Department of Justice as an enduring institution than with the tenure of any particular Attorney General. Above all else, if confirmed, I will work diligently to protect the professionalism and integrity of the department as an institution, and I will strive to leave it and the nation a stronger and better place. Thank you very much for your time today, and I look forward to answering your questions.
Thank you, Mr. Barr. We'll try to break around 11:30, I think, to get a quick bite and break up the day for you. But one thing I want to tell you is that I support the idea that politicians no matter what party, should not interfere with criminal investigations. That makes eminent sense to me. Once you go down that road, then the rule of law collapses. But there's another side to this equation, if I may say a two-way street. What about those in charge of enforcing the law? What about those with the power to bring charges against American citizens, including people up here? I remember Senator Stevens' case in Alaska. So we should always be on guard about the politician interfering in an investigation, but we should also have oversight of how the department works and those with this tremendous power use that power. Are you familiar with the January 11th New York Times article about FBI open inquiry into whether Trump was secretly working on behalf of Russians?
Yes, Mr. Chairman.
Would you promise me and this committee to look into this and tell us whether or not, in the appropriate way, a counterintelligence investigation was opened up by somebody at the FBI/Department of Justice against President Trump?
Yes, Mr. Chairman, I think there are a number of investigations, as I understand it, going on in the department.
Have you ever heard of such a thing in all the time you've been associated with the Department of Justice?
I have never heard of that.
Are there rules about how you can do counterintelligence investigations?
I believe there are, Mr. Chairman.
So if you want to open up one against the president, are there any checks and balances?
Not outside the FBI.
Okay, well, we need to look at that. In terms of people who are actually enforcing the law, don't we want to make sure they don't have an agenda?
That's right, Mr. Chairman.
Do you know a Lisa Page or Peter Strzok?
I've heard their names.
But do you know them personally?
No, I don't.
This is a message, August 8th, 2016, a text message. Trump's not ever going to become president, right? Right, Strzok responded. No, he's not. We'll stop him. Strzok was in charge of the Clinton email investigation. Ms. Page worked at the Department of Justice. August 15th, 2016. I want to believe the path you threw out for consideration in Andy's office, that there's no way he gets elected, but I'm afraid we can't take that risk. It's like an insurance policy in the unlikely event you die before 40. March 4th, 2016. Page to Strzok. God, Trump is a loathsome human being. October the 20th, 2016. Trump is an effing idiot, is unable to provide a coherent answer. To all those who enforce the law, you can have any opinion of us that you like, but you're supposed to do your job without an agenda. Do you promise me as Attorney General, if you get this job, to look in to see what happened in 2016?
Yes, Mr. Chairman.
How do these statements sit with you?
I was shocked when I saw them.
Okay, please get to the bottom of it. I promise you we will protect the investigation, but we're relying upon you to clean this place up. FISA warrants, are you familiar with a FISA warrant?
Yes, Mr. Chairman.
Okay. During the process of obtaining a warrant, is there a certification made by the Department of Justice to the court that the information being provided is reliable?
Yes, sir.
Are you familiar with Bruce Orr?
No, I'm not.
Bruce Orr was Associate Deputy Attorney General for Organized Crime and Drug Enforcement. His wife worked at Fusion GPS. Are you familiar with Fusion GPS?
Yes, I've read about that.
Fusion GPS, Mr. Barr, was hired by the Democratic National Committee and the Clinton campaign to do opposition research against candidate Trump and maybe other candidates. But we now know that they hired Fusion GPS, Michael Steele, who was a former British agent, to do opposition research and produce the famous dossier. Were you aware that Mr. Orr's wife worked for that organization?
I've read that.
Does that bother you if he had anything to do with the case?
Yes.
Are you aware that on numerous occasions he met with Mr. Steele while his wife worked with Fusion GPS?
I've read that.
Okay. The warrant certification against Carter Page on 4 different occasions certifies that the dossier, which was the main source of the warrant, was reliable. Would you look in to see whether or not that was an accurate statement and hold people accountable if it was not?
Yes, Mr. Chairman.
Mueller. You say you've known Mueller a long time. Would you say you have a close relationship with Mr. Mueller?
I would say we were good friends.
Would you say that you understand him to be a fair-minded person?
Absolutely.
Do you trust him to be fair to the president and the country as a whole?
Yes.
When his report comes to you, will you share it with us as much as possible?
Consistent with the regulations and the law, yes.
Do you believe Mr. Mueller would be involved in a witch hunt against anybody?
I don't believe Mr. Mueller would be involved in a witch hunt.
What are the circumstances that would allow a special counsel to be appointed, generally speaking?
Well, I appointed three, Mr. Chairman, a special counsel, and generally, when something comes up, an issue comes up that needs to be investigated, and there are good reasons to have it investigated by a special counsel outside the normal chain at the department, someone usually of public stature that can provide additional assurance of nonpartisan.
Do you believe that Attorney General Sessions had a conflict because he worked on the Trump campaign?
I'm not sure of all the facts, but I think he probably did the right thing recusing himself.
I agree. I think he did the right thing to recuse himself. Do you know Rod Rosenstein?
Yes, I do.
What's your opinion of him?
I have a very high opinion of Rod Rosenstein and his service in the department.
Okay. Why did you write the memo?
I wrote the memo because starting, I think, in June of 2017, there were many news reports, and I had no facts, and none of us really outside the department have facts. But I read a lot of news reports suggesting that there were a number of potential obstruction theories that were being contemplated, or at least explored. One theory in particular that appeared to be under consideration under a specific statute concerned me because I thought it would involve stretching the statute beyond what was intended, and it would do it in a way that would have serious adverse consequences for all agencies that are involved in the administration of justice, especially the Department of Justice. And I thought it would have a chilling effect going forward over time. And my memo is very clear that is the concern that was driving me. The impact, not the particular case, but its impact of a rule over time. And I wanted to make sure that before anyone went down this path, if that was in fact being considered, that the full implications of the theory were carefully thought out. So I wanted my views to get in front of the people who would be involved in, and the various lawyers who would be involved in those discussions. So I first raised these concerns verbally with Rod Rosenstein when I had lunch with him early in 2008, and he did not respond and was Sphinx-like in his reaction, but I expounded on my concerns. And then I later attempted to provide a written analysis as follow-up. Now, I initially thought of an op-ed, and because of the material, it wasn't working out. And I talked to his staff, and I said, you know, I want to follow up and send something to Rod in writing, but is he a one-pager kind of guy, or you know, how much will he read? And the guy said, he's like you. He doesn't mind wading into a dense
Don't you
legal
think
memo.
President Trump is a one-pager kind of guy?
Excuse me?
President Trump is a one-pager kind of guy.
I suspect he is.
Okay, just remember that. Go ahead.
Yeah. And so I provided the memo to Rod, and I provided it, distributed it freely among the other lawyers that I thought would be interested in it. And I think it was entirely proper. It's very common for me and for other former senior officials to weigh in on matters that they think may be ill-advised and may have ramifications down the road. For example, just a few months before that, I had weighed in repeatedly to complain about the idea of prosecuting Senator Menendez. I think I made 3 calls. I think it was 2 to Sessions, to AG Sessions, and 1 to Rosenstein. Now, I didn't know Senator Menendez. I don't represent Senator Menendez. No one was paying me to do it. And in fact, I don't support Senator Menendez politically. But I carefully watched this case. My friend Abby Lowell was his defense counsel, and it was very much like a line of cases that I had been concerned about when I was AG, and so I was watching it, and I thought the prosecution was based on a fallacious theory that would have bad long-term consequences, and so I freely weighed in at the department. And I did so because I care about the rule of law. And I want to say one final thing on the rule of law because it picks up on something you said, Mr. Chairman. What is the rule of law? We all use that term. In the area of enforcement, I think the rule of law is that when you apply a rule to A, it has to be the same rule and approach you apply to B, C, D, and E, and so forth. And that seems to me to suggest two corollaries for an attorney general. The first, that's why we don't like political interference. Political interference means that the rule being applied to A isn't the rule you're applying to every. It's special treatment because someone's in there exerting political influence. The corollary to that, and this is what you're driving at, Mr. Chairman, is that when you apply a rule, when a prosecutor is applying a rule to A, you've got to be careful that it's not torqued, especially for that case, in a way that couldn't be applied down the road, or if it is applied, will create problems down the road. And I think the Attorney General's job is both. It is both to protect against interference, but it's also to provide oversight to make sure that in each individual case, the same rule that would be applied broadly is being applied to the individual.
Thank you, Mr. Chairman. 6 quick yes or no questions. Will you commit to no interference with the scope of the special counsel's investigation?
I will, the scope of the special counsel's investigation
By not
is
limiting.
set by his charter and by the regulations, and I will ensure that those are maintained.
Will you commit to providing Mr. Mueller with the resources, funds, and time needed to complete his investigation?
Yes.
Will you commit to ensuring that Special Counsel Mueller is not terminated without good cause, consistent with department regulations?
Absolutely.
If Special Counsel Mueller makes any request, for instance, about the scope of his investigation or resources for his investigation, will you commit to notifying Congress if you deny that request?
I think the regulations require notification of Congress if there's a disagreement.
Thank you. And I have 2 questions from the chairman of the House Judiciary Committee. Will you commit to making any report Mueller produces at the conclusion of his investigation available to Congress and to the public?
As I said in my statement, I am going to make as much information available as I can, consistent with the rules and regulations that are part of the special counsel regulations.
Will you commit to making any report on the obstruction of justice public?
That's the same answer.
Thank
Yes.
you. In your June 2018 memo about obstruction of justice to the Mueller investigation, you repeatedly referred to Mueller's, quote, sweeping and all-encompassing interpretation of Section 1512, which is a statute on obstruction. How do you know what Mueller's interpretation of 1512 is?
Well, as I said, I was speculating. I freely said at the beginning, I was writing in the dark, and we're all in the dark. Every lawyer, every talking head, everyone who thinks about or talks about it doesn't have the facts.
So I spent my Saturday reading that memorandum.
Yeah.
So are you saying this is all your speculation? It's a big memo.
Well, it was informed to the extent that I thought that that was one of the theories being considered. And I don't know how seriously, whether it was being considered or how seriously it was being considered. But as a shorthand way in the memo of referring to what I was speculating might be the theory, I referred to it as Mueller's theory, rather than go in every time I mention it, say, well, this is
Do
speculative.
you know what Mueller's interpretation of 1512 is?
No, I don't know what Mueller's interpretation. But, and just one point, Senator, I think, you said in your opening statement, I said he was grossly irresponsible. I think I said if something happens, it would be grossly irresponsible. I was not calling Mueller grossly irresponsible.
I understand. Thank you.
Okay.
I appreciate that. Has anyone given you non-public information about Mueller's investigation?
I don't recall getting any confidential information about the investigation.
Your 2018 in it, you stated, and I quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he had a personal stake," end quote. Please explain what you base this conclusion on.
Yes. Here's the Department of Justice right here. And within the Department of Justice, enforcement decisions are being made. The president's over here. And I think of it as there are two categories of potential communications. One would be on a case that the president wants to communicate about that he has no personal interest in, no political interest in. Let's say the president's concerned about Chinese stealing trade secrets and say, I want you to go after this company that's being, that may be stealing trade secrets. That's perfectly appropriate for him to do, to communicate that. But whether it's bona fide or not, the Department of Justice's obligation and the Attorney General's obligation is not to take any action unless the Department of Justice and the Attorney General, reach their own independent conclusion that it is justified under the law, and regardless of the instruction. And that's my quote that everyone is saying, I'm sicking the, it's okay for the president to direct things. All I said was, it's not per se improper for the president to call on the department for doing something, especially if he has no personal or political interest in it. The other category of cases, and let's pick an easy bad example, would be if a member of the president's family or a business associate or something was under investigation and he tries to intervene. He's the chief law enforcement officer, and you could say, well, he has the power, but that would be a breach of his obligation under the Constitution to faithfully execute the laws. So, in my opinion, if a president attempts to intervene in a matter that he has a stake in to protect himself, that should first be looked at as a breach of his constitutional duties, whether it also violates a statute, depending on what statute comes into play and what all the facts are.
Including the emollients clause of the Constitution.
Well, I think there's a dispute as to what the emoluments clause relates to. I have not personally researched the emoluments clause. I can't even tell you what it says at this point. Off the top of my head, I would have said, well, emoluments are essentially a stipend attached to some office, but I don't know if that's correct or not. But I'm sure, I think it's being litigated right now.
I don't know either, so I'm going to try and find out. We'll come back another day and maybe discuss it. Your memo stated a fatal flaw in Mueller's interpretation of 1512C2 is that while defining obstruction solely as acting corruptly, Mueller offers no definition of what corruptly means. My understanding is that there's nothing in the public record that sheds light on his definition of obstruction. Do you know what his definition is?
I don't know what his definition is. I read a book where people were asking whether someone was, I don't know if it was accurate, but whether the president was acting with corrupt intent. And what I say in my memo is actually people don't understand what the word corruptly means in that statute. It's an adverb, and it's not meant to mean with the state of mind. It's actually meant the way in which the influence or obstruction is committed. That's its adverbial function in the statute, and what it means is, using it in the 19th century sense, it meant to influence it in a way that changes something that's good and fit to something that's bad and unfit, namely the corruption of evidence or the corruption of a decision maker. That's what the word corruptly means, because once you dissociate it from that, it really means very hard to discern what it means. It means bad. What does bad mean?
Let me go on because my time is so limited. You argue that and I quote, "The Constitution's plenary grant of those powers to the president also extends to the unitary character of the executive branch itself. Specifically, you argue, and this is a quote, while Mueller's immediate target is the president's exercise of his discretionary powers, his obstruction theory reaches all exercises of prosecutorial discretion by the president's subordinates, from the attorney general down to the most junior line prosecutor," end quote. So if the president orders the attorney general to halt a criminal investigation for personal reasons, would that be prohibited under your theory?
Prohibited by what?
By
The Constitution?
the Constitution?
I think it would be a breach of the president's duties to faithfully execute the law. It would be an abuse of power. Whether it would violate a statute depends on all the facts and what statute someone would cite me to. But I certainly think it would be an abuse of his power. And let me just say that the position...
Would that be the same thing if an attorney general fired U.S. attorneys for political reasons?
No, because U.S. attorneys are political appointments.
According to news reports, President Trump interviewed you and asked you to be part of the legal team defending him in the Mueller investigation twice. First in the spring of 17, when the investigation was just beginning, and again earlier this year. Is that correct?
No, no. I had one conversation with him that related to his private representation, and I can describe that for you. That was in June of 2017. That's the only time I met him before I talked to him about the job of Attorney General, which obviously is not the same as representing him.
Have you discussed the Mueller investigation with the president or anyone else in the White House?
I discussed the Mueller investigation, but not in any particular substance. I can go through my conversations with you if you want.
Well, not at this time, but I may come back to you
Okay.
and ask you about that. I don't want to take any more time. Thank you, Mr. Chairman.
Senator Bryce.
Before I ask my first question, and I don't want you to respond to this, I just want you to know what my interest is in the transparency of the Mueller report. When we spend I don't know whether it's $25 million or $35 million, the taxpayers, that's billions of dollars, the taxpayers ought to know what their money was spent for. So if you've got some reservations about some part of it not being public, I hope that that's related to traditional things that of the public's business that shouldn't be public, like national security as an example, not being made public. But beyond that, the only way I know for the taxpayers to hold anybody that spends the taxpayers' money responsibly is through transparency, because that brings accountability. My first question, as you would expect from our conversation in my office, 86, Reagan signed the False Claims Act. I worked hard to get that passed, especially provisions empowering whistleblowers to help government identify fraud. More than a decade ago, you said the key TAM provisions in the False Claims Act were, your words, an abomination and were unconstitutional. You said you, in your words, wanted to attack the law, but the Supreme Court upheld the law's constitutionality. Prosecutors from both sides of the aisle have praised the law as the most effective tool government has to detect and actually recover public money lost to fraud. Since 1986, the law that was passed in 1986 brought in $56 billion into the federal treasury. Most of that's because patriotic whistleblowers found the fraud and brought the case to the attention of the government. Is the False Claims Act unconstitutional?
No, Senator. It's been upheld by the Supreme Court.
Do you consider the False Claims Act to be an abomination?
No, I don't.
Does the False Claims Act benefit the taxpayer, specifically its provisions to empower and protect whistleblowers?
Yes, Senator.
If confirmed, do you commit to not take any action to undermine the False Claims Act? Further, if confirmed, will you continue current Justice Department staff and funding levels to properly support and prosecute False Claims Act cases?
Yes, I will diligently enforce the False Claims Act.
Now, with all those positive answers, you'd think I'd be done, wouldn't you, with that? But let me go on. Yeah, just to show you that there is some forces out there that I'm suspicious about within the Department of Justice, we have a new Department of Justice guidance document out last year known as the Granston Memo. Provides a long list of reasons that the department can use to dismiss False Claims Act cases, some of them pretty darn vague, such as preserving, these are their words, preserving government resources. Just think of all the mischief those three words can bring. Of course, the government can dismiss obviously meritless cases. I don't argue with that. But even when the department declines to participate in False Claims Act cases, the taxpayer can in many cases still recover financially. So it's important to allow whistleblowers to pursue cases even when the department isn't able to be involved. Under what circumstances can or should the Justice Department move to dismiss false claims cases?
Senator, I haven't reviewed that memorandum, so I'm not familiar with the thinking of the people in this. I think it's the Civil Division that did that, but if I'm confirmed, I will review it, and I would be glad to come and sit down with you and discuss it, and if there are areas they're concerned about, I'd be glad to work with you on that.
Unless you find that my presumption is wrong, that there's reasons to be suspicious, I hope you'll take into consideration my feeling about how in various suspicious ways people that are faceless bureaucrats can undermine this effort. In circumstances where the government doesn't intervene in false claims cases, if confirmed, will you commit to ensuring the department doesn't unnecessarily dismiss false act cases?
Yes, Senator, I will enforce the law in good faith.
Okay. Now, got an act that the Justice Department just took, and I can't obviously expect you to respond specifically to their act, but I use it as an example of their uncooperation with the Department of Congressional Oversight. This uncooperative behavior needs to change. On December the 10th last year, the department confirmed a briefing for your staff regarding asset forfeiture fund, and to do that last week, January the 8th. On January the 7th, Department of Justice Office of Legal or Legislative Affairs informed our staff that they will no longer provide the briefing because they consider the matter closed as a result of the change in chairmanship, and because you released a public memo, because I released a public memo on the Marshal Service study or investigation. It's important to gain your commitment on how you would handle this as an example. Let me explain how ridiculous it is to get somebody in this administration saying that they don't have to answer if you aren't chairman of a committee. We went through this in January, the first month this president was in office, when he said, or he put out a memo, we aren't going to answer any oversight except for chairman of committees. So you're going to write off 500 members of Congress not doing oversight. So we told them all about this and the constitutional cases on this. We got them up. They wrote a memo again 2 months later that said that they were going to respond to all this stuff. Now you got people in the bowels of the bureaucracy that are still saying, if you aren't a chairman, you ain't going to get an answer to anything. How ridiculous. It's our constitutional responsibility. So then I laid out, I'll give you an example. I sent the Justice Department a classified letter regarding information acquired from the Justice Department Inspector General report on the Clinton investigation. The department ought to answer for what the Inspector General has found, but I haven't heard a peep, not a peep, on that yet. On December the 10th, the Justice Department, well, I'm repeating here. So the question is, do you understand that if you're confirmed, you have an obligation to ensure the Justice Department, and particularly the FBI is a problem, respond to congressional inquiries, and to do it in a timely manner?
Absolutely, Senator.
Do you understand that this obligation applies regardless of whether you're a member of Congress or a committee chairman?
Yes, Senator. You and Senator Leahy, I think, are the only members of the committee now who were here 27 years ago when I was first confirmed. But I think you will recall that we were able to establish very cooperative and productive relationships with all the members and try to respond to their questions and deal with their concerns and work with them on projects they're interested in. And that will be the same approach that I will bring to the job if you confirm me.
Okay. Then let me be specific on my last question on oversight. You remember when you were in my office, I gave you, as I gave Attorney General Sessions, as I gave Holder, a long list of things that the department has not answered. And one of these was an October 17, 2018 letter. And I'd like to have your response to answering that letter and respond to all outstanding and future oversight requests in a timely manner. And then, remember, I said, all you cabinet people come up here to tell us yes when we ask you if you're going to answer our stuff. I said, maybe you better say maybe. So if you want to say maybe now and be really honest, say maybe. Otherwise, I hope you'll answer that October 17th letter once we get you voted into office.
Yes, Senator.
Throughout your career, you've expressed concern with congressional attempts to enact criminal justice reform and at times advocated for stricter mandatory minimum sentences. In '92, under your direction, DOJ published a report entitled "The Case for More Incarceration." This report declared that the problem with our criminal justice system was that we were incarcerating too few criminals. More recently, in 2015, you signed a letter opposing the Sentencing Reform and Corrections Act of 2015. This letter states quite clearly your opposition to sentencing reform, particularly the lessening of mandatory minimum sentences, any sort of retroactivity. The First Step Act was signed by President Trump. As Attorney General, it'll be your job to implement the legislation. Even though you've opposed criminal justice reform in the past, will you commit to fully implementing the First Step Act?
Yes, Senator. But in 1992, when I was Attorney General, the violent crime rates were the highest in American history. The sentences were extremely short. Typically, in many states, the time served for rape was 3 years. For murder, time served 5 to 7 years. It was, the system had broken down. And I think through a series of administrations, Reagan, Bush, and Clinton, the laws were changed, and we targeted chronic violent offenders, especially those using guns. And I think the reason the crime rate is much lower today is because of those policies. So I don't think comparing the policies that were in effect in 1992 to the situation now is really fair. And I think, and I've said, that right now we have greater regularity in sentencing. There's broader recognition that chronic violent offenders should be incarcerated for significant periods of time to get them off the streets. And I think the time was right to take stock and make changes to our penal system based on current experience. So I have no problem with the approach of reforming the sentencing structure. And I will faithfully enforce that law.
Don't take it personal if I raise my voice to you. I'm not mad at you.
If I were you, I'd answer his letters just as sort of a tip that may help you through your job if you get it. I'll take the time away from my second round. I'm very curious about the conversations you had about personal representation being Attorney General. You mentioned it, Senator Feinstein. Can you kind of give us a summary of what you were talking about?
Yeah, so in June of 2017, middle of June, Ambassador David Friedman, who's the U.S. ambassador to Israel, who I didn't know. I knew that he was a top-tier lawyer in New York and apparently a friend of the president's. He reached out to me, and we talked one evening, and he said that my understanding was he was interested in finding lawyers that could augment the defense team, and failing that, he wanted to identify Washington lawyers who had broad experience that whose perspective might be useful to the president's. And he asked me a number of questions like, what have you said about the president publicly? Do you have any conflicts and so forth? And I told him that I didn't think I could take this on, that I had just taken on a big corporate client that was very important to me and I expected a lot of work. And I said at my point in life, I really didn't want to take on this burden and that I actually preferred the freedom to not have any representation of an individual, but just say what I thought about anything without having to worry about that. And I said that my wife and I were sort of looking forward to a bit of respite, and I didn't want to stick my head into that meat grinder. He asked me if I would nonetheless just briefly go over the next day to meet with the president. And I said, sure, I'll go and meet with the president. And he brought me over and was squeezing me in. It looked to me like it was before the morning staff meeting because people were grouping by the door to get in, and I went in. And he was there, the ambassador was there, sat through the meeting. It was a very brief meeting where essentially the president wanted to know, he said, oh, you know Bob Mueller. How well do you know Bob Mueller? And I told him how well I knew Bob Mueller and how, the Barrs and Muellers were good friends and would be good friends when this is all over and so forth. And he was interested in that, wanted to know, what I thought about, Mueller's integrity and so forth and so on. And I said, Bob is a straight shooter and should be dealt with as such. And he said something to the effect like, so are you envisioning some role here? And I said, actually, Mr. President, right now I couldn't do it. My personal and my professional obligations are such that I'm unable to do it. So he asked me for my phone number. I gave it to him, and I never heard from him again until.
Well, I tried that once. You did better than
Well, I didn't hear from him until, later, but about something different, which was the Attorney General position.
Thank you, Mr. Barr. Good to see you again. As you mentioned, Senator Grassley and I were here at your hearing a number of years ago. Let me go back even before that. 46 years ago, I was not in the Senate. I was state's attorney in Vermont, and I watched with a great deal of interest the Elliot Richardson hearings. He'd been nominated to be Attorney General in the midst of Watergate. He made several commitments to the committee, including appointing a special prosecutor, and he promised to protect his independence. And as one who had total independence as an elected prosecutor in Vermont, I thought how important it was to have the same independence at the national level. And Mr. Richardson said it was necessary to create the maximum possible degree of public confidence in the integrity of the process. I've never forgotten that. But I think the integrity of our institutions is just as much at risk today. President Trump has made it clear he views the Justice Department as an extension of his political power. He's called on it to target his opponents. He obsesses over the Russia investigation, which looms over his presidency, may define it. He attacks the special counsel almost daily. He fired both the previous FBI director and attorney general for not handling the investigation as he pleased. That tells me the rule of law can no longer be taken for granted. So if confirmed, the president's going to expect you to do his bidding. I can almost guarantee you, he'll cross the line at some point. That's why the commitments you make here today, just like those I watched Elliot Richardson make years ago, matter greatly. So will you commit, if confirmed, to both seeking and following the advice of the department's career ethics officials on whether you must recuse from the special counsel's investigation?
I will seek the advice of the career ethics personnel, but under the regulations, I make the decision as the head of the agency as to my own recusal. So I certainly would consult with them, and at the end of the day, I would make a decision in good faith based on the laws and the facts that are evident at that time.
Same thing if you're talking about a conflict of interest?
Well, no, some conflicts, as you know, are mandatory.
I'm thinking what Attorney General Sessions, and when asked similar question, he said he'll seek and follow the advice of the Department of Justice's designated ethics officials. So let me ask you, maybe in a different way. I know you promised to not interfere with the special counsel. Are there any circumstances that would cause you to terminate the investigation or any component of it, or significantly restrict its funding?
Under the regulations, Bob Mueller could only be terminated for good cause, and frankly, it's unimaginable to me that Bob would ever do anything that gave rise to good cause. But in theory, if something happened that was good cause, for me, it would actually take more than that. It'd have to be pretty grave, and the public interest would essentially have to compel it, because I believe right now the overarching public interest is to allow him to finish.
I would agree with that, but I also think over the past 18 months, you rather harshly prejudged the investigation in some of your writings.
Well, I don't see that at all, Senator. You know, when you strip away a lot of the rhetoric, the two things that have been thrown up as me sort of being antagonistic to the investigation are two things. One, a very mild comment I made that, gee, I wish the team had been more balanced. I wasn't criticizing Mueller. I believe that prosecutors, and I think you would agree, they can handle the case professionally, whatever their politics are. A good prosecutor can leave their politics at the door and go in and do the job. And I think that's what Justice Department prosecutors do in general.
But you also are very critical of the Russian probe. And I mean, I can't think of anything that would, in your memo, for example, that would jump out more for this president because of his commitment to it. And I ask that because some have said, on both sides, that it looked like a job application. And so that's what I want you to refer to.
Well, that's ludicrous. If I wanted the job and was going after the job, there are many more direct ways of me bringing myself to the president's attention than writing an 18-page legal memorandum,
Or
sending it to the
criticizing-
Department of Justice and routing it to other.
But also publicly criticizing a Russian probe. I mean,
How have I criticized the Russian probe?
you don't have any criticism of the Russian probe?
Not at all. I believe the Russians interfered or attempted to interfere with the election, and I think we have to get to the bottom of it.
So you would be in favor of releasing the investigative report when it's completed?
As I've said, I'm in favor of as much transparency as there can be, consistent with the rules and the law.
Do you see a case where the president could claim executive privilege and say that parts of the report could not be released?
Well, I don't have a clue as to what would be in the report. The report could end up being, not very big. I don't know what's going to be in the report. In theory, if there was executive privilege, material to which an executive privilege claim could be made, it might, someone might raise a claim of executive
That'd
privilege.
be pretty difficult following U.S. versus Nixon when the Supreme Court unanimously rejected President Nixon's claims of executive privilege over the Watergate tapes. But I ask it because the president's attorney, Mr. Giuliani, said the president should be able to correct the Mueller report before any public release. So in other words, he could take this investigative report, put his own spin on it, and correct it before it's released. Do you commit that would not happen if you were Attorney General?
That will not happen.
Thank you. You had, when you're AG, I remember this well because I was here in the Senate at the time, you encouraged President George H.W. Bush to pardon all 6 individuals who were targeted in Iran-Contra. The independent prosecutor investigating the matter labeled that a cover-up. Now, you and I talked about this in my office, and I appreciate you coming by. I found the conversation the two of us had be well worthwhile. Do you believe a president could lawfully issue a pardon in exchange for the recipient's promise to not incriminate him?
No, that would be a crime.
Thank you. In 1990, you argued that Congress appropriation power is not an independent source of congressional power to control the allocation of government resources. There are only 3 committees in the Senate to have a vice chairman. Appropriation is one of them. Obviously, as vice chairman, I kind of looked at that. You claim that if a president finds no appropriated funds within a given category, he may use funds from another category, as long as both categories are in his constitutional purview. Now, it says Vice Chairman Appropriations Committee. Don't be surprised, I disagree. Congress's power of the purse, Article 1, Section 9, I believe constitutes one of the most fundamental and foundational checks and balances on the executive branch. So do you believe the president can ignore Congress appropriations allocations, conditions, and restrictions in law? Just ignore them and take the money and transfer it?
Not as a general proposition, but that was a
general proposition.
I actually thought that was a good law review article. I gave it as a speech, and it was really a thought piece, and what I was really saying was, and I say right up front, that the more I thought about the appropriations power, the more confused I got, and I was just laying out a potential template, which is this. People frequently say, the power to, spend money on this division or this missile system is part of the power of the purse. And what I was actually saying was, actually what the power being exercised there is the substantive power that Congress has to raise armies. And it's not, it doesn't come from the power of...
specific appropriations on agriculture or on defense. I mean, for example, could a president just build a wall along our southern border because he wanted to and just take the money, whether appropriate or not? What about eminent domain?
What about eminent domain?
Well, if you're going to build a wall, you got to take a whole lot of land away from landowners in Texas and elsewhere.
Well, you'd have to show me what statute is being invoked and also what appropriations is being used. I can't answer that in the abstract.
So you're saying the president, though, can have the power to go into money even if the Congress is appropriated for a different purpose?
I didn't say that. But some...
You mean that?
I don't mean that. I'm saying that, there are monies that the president may have power to shift because of statutory authority.
But that would have been because Congress gave him that authority.
Right.
not because he has it automatically.
I'm not taking that position. As I said, my law review, it was published as a law review article, and it was a thought piece exploring what limits there might be to the appropriations power and where Congress's power comes from in certain areas.
Thank you. Thank you, Mr. Chairman.
Just to follow up on that real quick, and I won't take this against their corner. Did the Article 2 powers, the inherent authority of the Commander-in-Chief, give him the ability to take appropriated dollars for the Department of Defense and build a wall?
I can't, without looking at the statute, I really couldn't answer that.
I'm not talking about a statute, I'm talking about the inherent authority of the President as Commander-in-Chief.
That's the kind of question I would go to OLC to
Okay.
answer.
Get back with us on that. Senator Corn.
Well, Mr. Chairman, let me congratulate you on your election as chairman of the Judiciary Committee and tell you we look forward to working with you and supporting this committee's efforts. Thank you for convening today's hearing. And I want to express my profound and sincere thanks to the nominee, Mr. Barr, for agreeing to serve a second time as Attorney General. I noted in your statement, you said it was 27 years ago that you sat in this chair and went through your first confirmation hearing. And to me, that says a lot about your character and your commitment to the rule of law, that you would be willing to go through this process again and serve once again as the chief law enforcement officer of the country. Thank you for doing that.
Thank you, Senator.
Thank you to your family as well. To me, the Attorney General is one of the most challenging cabinet offices to hold because, as you point out in your opening statement, you are committed to the rule of law and enforcing the laws of the land, but you are also a political appointee of a president. If you are serving another cabinet position, certainly you're committed to implementing the president's agenda or the agenda of an administration, but as Attorney General, that is not an unequivocal commitment, because there may be some things that the administration wants you to do that you cannot do consistent with the rule of law, correct?
That's right, Senator. One of the reasons I ultimately decided that I would accept this position if it was offered to me was because I feel that I'm in a position to be independent. You know, over the years, a lot of people have, some politicians have called me up saying, you know, I'm thinking of going for the Attorney General position in this administration and so forth. And I say, you're crazy. Because if you view yourself as having a political future down the road, don't take the job. Because if you take this job, you have to be ready, you know, to make decisions and spend all your political capital and have no future. Because you have to have that freedom of action. And I feel I'm in a position in life where I can do the right thing and not really care about the consequences, in the sense that I can truly be independent.
Mr. Barr, thinking back about the run-up to the 2016 election, where the nominee of both political parties for President of the United States ended up being investigated by the FBI, can you think of any precedent in American history where that's occurred that you know of?
No, I can't, Senator.
And thinking back to James Comey's press conference of July the 7th, 2016, where he took the step of talking about the evidence against Mrs. Clinton, talking about the legal standard that would apply as to whether she might or might not be indicted for committing a crime under the Espionage Act. Have you ever seen a situation where an FBI director would usurp the authority of the Department of Justice to make that charging decision and hold a press conference and talk about all of the derogatory information that the investigation had gleaned against a potential defendant, and then say, now we're not going to, no reasonable prosecutor would indict her? Have you ever seen anything like that happen before?
No, I've never seen that, and I thought it was a little bit, more than a little bit. It was weird at the time, but My initial reaction to it was, I think Attorney General Lynch had said something, she was under pressure to recuse herself, I think, because of the so-called tarmac meeting. And I think she said something like she was going to defer to the FBI. So my initial reaction to that whole thing was, well, she must have agreed, or it must have been the plan, that he was going to make the decision and go out and announce his decision.
Under the normal rules, if the Attorney General has a conflict of interest.
It would go to the deputy.
It would go to the deputy.
Correct.
Not to the FBI director to make that decision, correct?
Right, so that's why I thought it was very strange, but I think later it became clearer, to the extent there's anything clear about it, that I don't think Attorney General Lynch had essentially delegated that authority to the director. And I think Jim Comey, as I've said, is an extremely gifted man who's served the country with distinction in many roles. But I thought that to the extent he actually announced a decision was wrong. And the other thing is, if you're not going to indict someone, then you don't stand up there and unload negative information about the person. That's not the way the Department of Justice does business.
I was shocked when Mr. Comey later wrote a letter saying that based on the discovery of Clinton emails on the Wiener laptop, that they were reopening the investigation that he had already announced closed. And then finally, just days before the general election, November the 6th, 2016, said, we didn't find anything on the laptop that would change my conclusions based on the press conference of July the 6th. Did you likewise find that to be an extraordinary, I will use the word bizarre, but certainly unprecedented event?
Yeah, the whole sequence was very herky-jerky and bizarre. But at that time, I was a little of a contrarian in that I basically took the position that once he did what he did in July and said the thing was over, and then found out it wasn't over, he had no choice but to correct the record. So I said that he had no choice but to do what he did, but it sort of shows you what happens when you start disregarding the normal procedures and established practice, is that you sort of dig yourself a deeper and deeper hole.
Why is it that the Department of Justice rules, which also apply to the FBI, make it clear that our chief law enforcement agencies in this country should not get tangled up in election politics? Are there policies in place that try to insulate the investigations and the decisions of the Department of Justice and FBI from getting involved in elections?
Yes, Senator, there are.
And why is that?
Well, obviously, because the incumbent party has their hands on the, among other reasons, they have their hands on the levers of the law enforcement apparatus of the country, and you don't want it used against the opposing political party.
And that's what happened when the counterintelligence investigation of the Trump campaign began in late July and continued on through, well, presumably to Director Comey's firing and beyond.
Well, I'm not in a position to, make a judgment about it because I don't know what the predicate was for it. I think I said, it's strange to have a counterintelligence investigation of a president, but I'm not, I just don't know what the predicate is, and if I'm confirmed, I assume I'll find out.
Rod Rosenstein's memo recommending the termination of James Comey as FBI director was dated May the 9th, 2017. It's entitled Restoring Public Confidence in the FBI. I take it you've read the memo, and do you agree with its conclusion?
I completely agree with Rod Rosenstein, and I thought the important point he made from my standpoint was not the particular usurpation that occurred, but it was, as I think he says, that Director Comey just didn't recognize that was a mistake, and so it was going to potentially be a continuing problem, that his appreciation of his role vis-a-vis the Attorney General.
As I said, the title of the memo is Restoring Public Confidence in the FBI. Do you agree that restoration of public confidence in the FBI and Department of Justice as a apolitical or non-political law enforcement organization is important?
It's critical.
And needed.
It's critical, and that's one of the reasons I'm sitting here. I'd like to help with that process.
Well, Mr. Barr, I think you're uniquely qualified to do that, and I wish you Godspeed.
Thank you, Senator.
It couldn't be more important. Thank you.
Mr. Barr, we've never had a chance to meet, but I welcome you to this committee.
Thank you.
You seem like a rational person. I'd like to ask you a question. When you consider what Jeff Sessions went through as the Attorney General for President Donald Trump, where he was subjected to unrelenting criticism, primarily because, as a matter of conscience, he decided he had a conflict of interest and should remove himself from any decisions by the special counsel concerning the Russia investigation. When you consider that this president has lashed out on a personal basis against federal judges who ruled against his administration, when you consider the criticism which he has leveled at the chief law enforcement investigative agency of the Department of Justice, the FBI, as well as our intelligence agencies, when you see the exit lanes glutted, those leaving the White House at every single level, why do you want this job?
Well, because I love the department, I love and all its components, including the FBI. I think they're critical institutions that are essential to preserving the rule of law, which is the heartbeat of this country. And I'd like to think that there was bipartisan consensus when I was last in this position, that I acted with independence and professionalism and integrity, and I had very strong and productive relationships across the aisle, which were important, I think, to trying to get some things done. And I feel that I'm in a position in life where I can provide the leadership necessary to protect the independence and the reputation of the department and serve in this administration.
A number of my colleagues on both sides have asked, and I'll bet you'll hear more, questions along the line of what would be your breaking point? When would you pick up and leave? When is your Jim Mattis moment when the president has asked you to do something which you think is inconsistent with your oath? Doesn't that give you some pause as you embark on this journey?
It might give me pause if I was 45 or 50 years old, but it doesn't give me pause right now because I had a very good life. I have a very good life. I love it. But I also want to help in this circumstance, and I am not going to do anything that I think is wrong, and I will not be bullied into doing anything I think is wrong by anybody, whether it be editorial boards or Congress or the president. I'm going to do what I think is right.
You have a very nice family behind you.
Thank you.
I'm glad you introduced.
Thank you, sir.
And I don't want to give your grandson any career advice. He's received quite a bit this morning already. But he ought to consider, at least for some balance, being a public defender. One of the things that you alluded to as a major issue of concern is immigration, and I'm glad you said it. Our government is shut down now over the issues of border security and immigration, and the Attorney General plays a central role, which many people don't know as they look at the Department of Homeland Security for most of the action on the issue of immigration. I was surprised at the exit interview by General Kelly when he said, and I'm paraphrasing, that Attorney General Sessions was responsible for the zero tolerance policy that was announced in mid-2018, and that it was because of that policy, that was one of the reasons why he was being asked to leave. That's the first I'd ever heard. Are you familiar with the zero tolerance policy?
Generally, Senator, yes.
I can tell you that it was an effort to take escorted children, infants, toddlers, and children, and forcibly remove them from their parents at the border This policy by our government separated up to 2,800 of those children and put them into the system, the same system as unaccompanied children. The results were horrible. I saw them firsthand. And you have alluded in your opening statement to stopping people from crashing through the border, breaking and flouting the laws. Those young children, for the most part, were being brought to this country by their parents to seek asylum. You can present yourself at America's border and seek asylum legally, can you not?
Yes, Senator, you can.
So separating those children from their parents in an effort, as Attorney General Sessions explained, to get tough with families presenting themselves at the border, was a policy decision on his part. Do you agree with that policy decision?
Well, I'm not sure I know all the details, because one of the disadvantages I have is I'm not in the department and don't really have the same backing I did in terms of information that I had last time. But my understanding is that DHS makes the decision as to who they're going to apprehend and hold. Now, you can claim asylum, but that doesn't mean you can waltz into the country
No,
freely.
of course not.
Okay, and you have to be processed. And my understanding is a majority of people do not qualify for asylum. But DHS makes a decision who to hold and charge with the crime of illegal entry. And then they refer it to the Department of Justice. And I believe the department's policy, when the department says zero tolerance, they're saying whatever DHS refers to us in the way of illegal entry prosecutions, we'll prosecute. Now what is being done, because I think the administration has changed the policy, is DHS is not referring for prosecution family units that would lead to the separation of children from the family unit.
It's true that the President and the administration abandoned the policy after there was a public reaction to the separation of these children. I'm concerned, I want to go back to your University of Virginia Mueller Center speech, which is...
It's a gem, isn't it?
It's a classic, and it goes back many years. But you described your previous tenure as Attorney General, and you said, after being appointed, I quickly developed some initiatives on the immigration issue that would create more border patrols, change immigration rules, streamline processing. It would furthermore put the Bush campaign ahead of the Democrats on the immigration issue, which I saw as extremely important in 1992. I felt that a strong policy on immigration was necessary for the President to carry California, a key state in the election. That's a pretty revealing statement about a political agenda.
Yeah, there's nothing wrong with that, because as I've said, you know, the attorney, and I've spoken on this a number of times, there's sort of three roles the Attorney General plays. One is the enforcer of the law, and that the role of the Attorney General is to keep the enforcement process sacrosanct from political influence. The second one is as legal advisor, and that is in the Judiciary Act of 1789, legal advisor to the President and the Cabinet. And there I say the Attorney General's role is to provide, you know, unvarnished, straight from the shoulder legal advice as to what the Attorney General believes is the right answer under the law. And then the third role is the policy role, which is law enforcement policy, which includes immigration policy. And there you are a political subordinate of the President, and it's okay to propose policies that are politically advantageous.
Well,
but I have to say that, you know, that was casual conversation. The point was I was pursuing a strong immigration policy even when I was deputy, long before, you know, the election was on the horizon. And in traveling around the country, visiting the border, paying a lot of visits to California, I saw how important the issue was, and I thought the administration had to be more responsive to it. And yes, there was a political benefit to it.
I just have a short time left. The chairman, our new chairman, congratulations, Graham, noted 10 years of work by a number of us on this committee on a bipartisan basis to deal with criminal sentencing and prison reform. And the First Step Act, signed by the President around Christmas, I think is a significant departure. I learned, as many have, that the approach, the get tough approach that we imposed with 100-to-1 sentencing disparity between crack and powder didn't work. Did not work. The number of drugs being sold on the street increased. The price of the drugs went down. The people being incarcerated went up dramatically. And we learned the hard way. That was not the way to deal with the issue. And now we're trying to clean up 10 years later, or more, 25 years later, from the 100-to-1 disparity. I voted the wrong way on 100-to-1. Now I know, in retrospect. You've made some hardline statements about this issue in criminal sentencing in the past. And many of us believe, on a bipartisan basis, we've got to look at this anew and not repeat these mistakes again. So I would like to hear your assurance that you have learned, as I have, that there is a better way, could be a more effective way, and that as Attorney General, you will help us implement the First Step Act and design the second step.
Absolutely, Senator. From my perspective, the very draconian penalties on crack were put into place initially because when the crack epidemic first hit, it was like nuclear weapons going off in the inner city. And as I think you'll recall, a lot of the community leaders at that time were saying, you gotta, this is killing us, you have to do something. So the initial reaction of draconian penalties was actually, trying to help those communities. And over time, and now the same leaders are saying to us, this has been devastating, generation after generation of our people are being incarcerated, have been incarcerated and lost their lives because of this, and you have to change the policies. And I think that is, we should listen to the same people we were listening to before. I supported generally strong penalties on drugs because, not just crack, because I felt the money involved was so high that, you needed something to counteract that. I also said repeatedly over the years of the drug war that I felt that the head of the snake is outside the country. And the place to fight this aggressively is at the source more than on the street corner. And I used to say we could, stack up generation after generation of people in prison and it'll still keep on coming. And so I always felt that, and I support a adjustment to these sentences and the safety valve and so forth. To me, the corollary is we have to really start thinking and using all our national forms of power in the sense of our diplomacy and our economic leverage and so forth to get better results overseas. So, for example, now fentanyl is sort of the new crack. Fentanyl and fentanyl analogs are sort of the new crack, and they're coming in from China. So,
Across the Mexican border.
correct.
At ports of entry, 90%.
Mm-hmm. So that's a long-winded answer to your question, which is I understand that things have changed since 1992. I held on a little bit longer to keeping strong sentences maybe than others. Part of that was I wasn't involved in the business anymore. I wasn't at Justice Department looking at reports and studies, learning about different things in the country. I was, arguing with the FCC about telecommunications rules. So,
Ms. Barr?
yes.
That was a great answer, and it was long-winded.
Okay.
Senator Lee.
Mr. Barr,
After this, we'll break to 12:15 for lunch and a comfort break.
Mr. Barr, thank you very much for your willingness to spend time with us today and your willingness to be considered for this important position yet again.
Thank you.
Great to have your family here. And I can't help but comment, a lot of people have talked about Liam today, probably more than any of his other friends or classmates, people of his age cohort. People were thinking about what he might do for a living. Unlike some of my colleagues who have suggested medicine, I want to just sort of suggest what I've suggested to my 3 children, which is that I'm not going to push them into any career choice, which in our family means that you can be any kind of lawyer you want. Just keep that in mind with Liam. I'd like to talk to you first about civil asset forfeiture. As you know, civil forfeiture and criminal forfeiture are two very different things, two very different species of government taking someone's asset. With criminal forfeiture, of course, the government's ability to take something away is predicated upon a conviction of a crime. With civil asset forfeiture, that happens even in the absence of a conviction. There are some serious questions, of course, regarding the legality and constitutionality of civil asset forfeiture. Justice Thomas, for example, has questioned whether some of these practices are constitutional. I was encouraged to note that in your testimony in 1991, you identified this as an issue. When you testified before this committee, you criticized what you described as the speed trap mentality of forfeiture. Your point was that, quote, agencies should not feel that just because they seize money, they're going to get the money, close quote. Now, since 1991, I've seen our government, our law enforcement agencies actually move more toward this sort of speed trap mentality rather than away from it, as many of us would have preferred. Too often, law enforcement agencies have too strong an incentive to use civil asset forfeiture in a way that lines their own coffers outside of the relevant appropriations process. So let me just ask you the question: Do you think that the speed trap mentality is a problem? And if so, is that something that you'll work to address within the Department of Justice if you're confirmed?
Yes, I think constant vigilance is necessary because, there are incentives there that should be of concern in administering the law. And I understand that there are some people who are concerned about it, have some horror stories. The people at the Justice Department have been trying to clamp down. I think Attorney General Sessions put out some guidelines that were supposed to address that. I haven't gotten into it myself. I plan to get into it and see exactly, what the horror stories are, where the problems and potential abuses are, and also whether Attorney General Sessions' guidelines are providing sufficient protection. At the same time, I think it is a valuable tool in law enforcement, and the state and local law enforcement officer, our partners, it's very important to them. So I want to make sure we strike the right balance. And once I have a chance to review it, I'd be glad to come up and talk to you about that.
Thank you. I appreciate that. I understand that it's a tool that many consider valuable, but a tool that can be considered valuable for some of those same reasons. Something that's considered valuable to the government can, in many instances, jeopardize an individual right that is protected under the Constitution. We've got to be careful of that. When you refer to the partnership that sometimes takes place between state and federal authorities, this is sometimes where we see it abused. In the case of procedure known as equitable sharing, where sometimes state law might prohibit the use of civil asset forfeiture under certain circumstances. And in those circumstances, those state law enforcement agencies might work with federal law enforcement for the specific purpose of evading state law that would otherwise prohibit that. So I hope that's something you'll look into as well.
Yes.
Let's talk about antitrust for a minute. Along with Senator Klobuchar, I chair the antitrust subcommittee. And as I'm sure you're aware, there are a growing number of people who take the position, who embrace the viewpoint that we should use antitrust law to address a whole host of social and economic harms, to, among other things, to ensure that companies respect the First Amendment, or to prevent large companies from becoming too big, or to shape labor markets, or to conform industries to a particular aesthetic, or achieve some other broadly defined social interest. I'd like to know what your view is on this. Are you a believer in the sort of big is bad mentality, or do you gravitate more toward the idea that our antitrust laws are there to protect consumers and should focus on consumer welfare and prices that consumers face?
Yes, I mean, generally, that's where I stand, which is the purpose of the antitrust laws, obviously, is to protect competition, and that competition, it is competition that ultimately redounds to consumer benefits. At the same time, I'm sort of interested in stepping back and reassessing or learning more about how the antitrust division has been functioning and what their priorities are. I don't think big is necessarily bad, but I think a lot of people wonder how such huge behemoths that now exist in Silicon Valley have taken shape under the nose of the antitrust enforcers. And they're, you know, you can win that place in the marketplace without violating the antitrust laws. But I want to find out more about that dynamic.
Right. Yeah, and in some circumstances, a company that becomes too big ends up behaving in a way and exerting market dominance in a way that impairs consumer welfare anti-competitively. In other circumstances, consolidation can bring about lower prices and increased competition. I assume you wouldn't disagree with either of those statements.
No, Senator.
As you know, and as several of my colleagues have mentioned, President Trump signed into law the First Step Act about a month ago. This is legislation that I applaud and legislation that I've been working on in one way or another for 8 years, and was pleased to team up with Senator Grassley, Senator Durbin, Senator Booker, and others to work on that over the course of many years. As you know, the Attorney General has an important role under the First Step Act in appointing members to something called the Independent Review Commission. That Independent Review Commission will make recommendations concerning which offenders might be eligible for earned credits under this legislation and which programs will be approved. When we drafted this legislation, there were some members who were concerned that whoever was the Attorney General at the time of this law's passage and implementation might be able to undermine the effectiveness of this law by appointing members who didn't agree with or believe in the objectives of the bill. So will you commit to me, Mr. Barr, that you will appoint people to that Independent Review Commission who are honest brokers to decide which offenders should be eligible and which programs should be eligible to participate?
Yes, Senator.
Thank you. You familiar with the Ashcroft-Sessions policy, namely the policy requiring prosecutors to charge the most significant, readily provable offense?
Yes, Senator.
Tell me how that should best be balanced out with the discretion of a prosecutor, most frequently, of course, with the discretion of a local U.S. Attorney's office.
Well, I was going to say, I think the best way of balancing it out is to have a supervisor who is able to approve departures from that policy based on the specific circumstances. And there are countless different, permutations of facts that might justify a departure from it. So I think it's best handled by supervisory people. But I also think it has to be looked at centrally. I'm not saying that each case has to be approved centrally, but there has to be some monitoring of what's going on because, as you know, one of the things that led to the sentencing guidelines was, just big differences in the way the laws were being applied and enforced around the country. And I think we need to try to strive for as much uniformity as we can.
But you intend to continue that policy?
Yes.
And
unless someone tells me a good reason not to.
If I'm understanding you correctly, you're saying that if you do follow it, you will defer to the judgment of the office in question in the case of determining